Start with arguments in the case of State of Ohio versus Rudney Stutzman. That's case number 18AP0038. Both parties are represented by counsel, so you'll each have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. If you're going to reserve time, let me know and I'll try to keep you appraised of how far in the argument you are. The arguments are recorded and posted on the court's YouTube channel, so we ask that you please remain at the podium and keep your voice up so that there is a good recording of your argument. The court has read the briefs and we're ready to proceed if you are.
Good morning. May it please the court, my name is John Williams, Assistant Prosecuting Attorney for Wayne County. I'm appearing on behalf of the State of Ohio in this case. We acknowledge that we have a difficult burden in this case. We must establish that the trial court abused its discretion by, again, finding the defendant, Rudney Stutzman, incompetent. We know that this court does not take that lightly, nor do we. But there comes a point at which, after repeated hearings on the issue and a number of witnesses presented by the state all agreeing on this, we have to call that discretion into question. The hearing on this case was just about a year ago, and at that time, the state first presented the testimony of Dr. John Tilley. He was the evaluator, independent evaluator, hired by Twin Valley Behavioral Health Care to evaluate Mr. Stutzman again. He had done over 2,000 evaluations, a dozen on serious charges like murder. He'd had 2 contacts with Mr. Stutzman, interviewing him and testing him, and a 3rd contact with defense counsel and the defense's evaluator. He reviewed previous reports of evaluations, hearings on Mr. Stutzman's competency, and of particular interest, he interviewed staff at Twin Valley Behavioral Health Care. What has been your experience with him? And that is one of our main points in this matter. One of the things that he did, and was a matter of significant contention at the hearing, was he administered the gold standard of malingering tests, what is known as the structured interview of reported symptoms, 2nd edition, referred to as SIRS 2. He administered that test, and it was indicative to him of malingering. Of particular interest was the fact that the defense expert, Dr. Ashkenazi, had also previously administered a SIRS 2 test and gotten similar results, but she decided to invalidate that test when she administered it. Her explanation was, well, the defendant was actively psychotic. Well, the fact is that test is made to determine, is someone actively psychotic or are they malingering? And Dr. Tilley separated out, no, it's not actively psychotic, it's grossly psychotic. If someone is incoherent to the point of being incommunicative, catatonic, speaking in word salad, yes, you don't administer the test. But to someone who is actively psychotic, yes, that's what the test is meant to determine. It is to be done for that purpose. At the end of everything, after having interviewed every person that he thought was relevant to Mr. Stutzman's stay at Twin Valley administering test, he concluded that Mr. Stutzman was not suffering from a severe mental illness and was malingering, and therefore did not even meet the first standard for incompetency. The state next called Dr. Delaney Smith. She had known Mr. Stutzman since his first admission, had been his treating psychiatrist, and had extensive experience with him. Her experience in the field was extensive, her qualifications extensive. She had weekly contacts with him for years and saw him intentionally I believe her term was thrusting forward certain symptoms, which in her experience were inconsistent with the psychosis being claimed, and they kept coming up around court hearings. When there was going to be a court hearing, things would suddenly start to get more significant.
Counsel,
Yes.
one of the things that the appellee is saying here about your argument that he would change his behavior around the time of court hearings was the fact that there was no evidence presented that he even knew when court hearings were scheduled.
Actually, having knowledge that there was a specific court hearing scheduled, no. What would happen is that the evaluator would come in and speak to him to get prepared for a court hearing. He would inquire into what this was for. You know, is this so I can get a civil commitment or this? When they would tell him what it was for, his demeanor would change. And that was how they reached that conclusion, that his demeanor and his behavior would change when he realized, you know, we're going to evaluate again whether you're competent or not.
Thank you.
There was also, she, in the end, also concluded that Stutzman was malingering and that he was not suffering from a severe mental illness.
Excuse me, again, I apologize, but with that, she hadn't seen him in what, a year?
She had not.
And so did she testify to anything different than she had testified to the other two competency hearings? As to restoration of competency?
No, basically hers was historical. Marla Yoder-Teet, who basically spanned, she was a licensed independent social worker. Her experience pretty much spanned Mr. Stutzman's stay at Twin Valley. And basically her job was to the restoration of competency classes, so to speak. And she found that he exaggerated and feigned symptoms of mental illness, and that once again, this was particularly seemed to occur more significantly when there was a court hearing upcoming, when he was being evaluated to redetermine whether or not he was competent. She also found that his symptoms were not consistent with psychosis. She believed he was malingering and that he was not severely mentally ill. Dr. David Sainer, he was current treating psychiatrist. He did see Mr. Stutzman over several different periods during his stay there, but more recently, and he was the treating psychiatrist at the time of the hearing. He believed that Mr. Stutzman suffered from narcissistic personality disorder, which is a personality disorder but not a severe mental illness, that explained a lot of his entitled and demanding behavior, but did not rise to the level of psychosis, and that most of the psychotic symptoms he presented were not consistent with his experience of psychosis. He believed that the defendant did not suffer from a severe mental illness and that he was malingering. Finally, even a registered nurse, David Crawford, with 30 years of experience, said his observations of Rudney Stutzman were not consistent with what he had observed for 30 years in other patients who were genuinely psychotic.
Counsel, what weight should the testimony of the nurse and I believe one of the witnesses offered by the state was a social worker, what weight should their testimony carry in a competency hearing?
As to competency, education, training, and experience are the standards for determining expert testimony.
And I guess perhaps my better question would be, what weight should their opinion carry, not their testimony?
perhaps less, but perhaps their opinion and their experience should have some contribution, because they do have the experience and they have the daily hands-on, where sometimes the professionals do not have that.
Attorney Williams, let me interrupt you just briefly because you're at 5 minutes 41 seconds total time left, and you did not indicate if you wanted to reserve time for rebuttal. Do you want to reserve time?
I'll reserve a couple of minutes if I
Okay,
may.
I'll let you know when you get close to that.
Abuse of discretion requires unreasonable, arbitrary, and unconscionable actions by the trial court. Incompetency, you either have to establish that the defendant does not understand the nature and objective of proceedings or is incapable of assisting in his own defense. The Ohio Supreme Court in Vrabel said that they can be emotionally disturbed, even psychotic, but still capable of assisting. A lack of cooperation with counsel does not equal incompetence. And statutorily, there is a presumption in favor of a finding of competence. In Moss, in the 8th District, the court did find that there was abuse of discretion based on the history of the defendant. And that's what we're talking about here, is history. What has been observed for several years, since 2011, there have been these observations of the defendant, Mr. Stutzman. It is proper for a court to consider that as a defendant develops some understanding of competency issues, he may try to influence determination by his actions. We're not claiming that the court acted unconscionably. We are saying that the court's actions were unreasonable in light of the extensive evidence that the defendant was malingering and not suffering from a severe mental illness, and that they were arbitrary in that the court reflexively repeated its same determination, perhaps being reluctant after twice finding the defendant incompetent to change his behavior. This court has questions. Thank you.
All right, you'll have 3 minutes and 47 seconds then for your rebuttal time. Counsel, 15 minutes.
Morning, Your Honors. I'm David Doughton, along with John Leonard, on behalf of Mr. Stutzman. Clearly, this isn't a weight of the evidence issue. The question is whether there's a basis in the record that the judge could reasonably find him to have been incompetent. One of the things I want to note, I believe the prosecutor indicated that there was evidence that the expert had told Mr. Stutzman they were preparing for a hearing. I don't know where that is in the record. I've been through the record. I've been through 3 hearings. Perhaps a prosecutor will let us know, but I have no idea where that was. In fact, I was the attorney who was with Dr. Tilley. Let me say this. The relationship with the prosecutors has been entirely professional. They have acted in good faith. I have no issue here. At one point, Mr. Williams had indicated, a big issue we had is the ability to work with counsel, and he said, you're really kind of an advantage because we need our expert to be able to watch you interact, which we agree with. I think that's a fair position. And so we agreed to allow Dr. Tilley to sit and watch your interaction, to be fair about this. And I'll say at that meeting, and it didn't come out in the testimony, there was nothing about what was upcoming or not upcoming. He's in a health facility, a mental health facility. It's not unusual to have doctors talking. I don't know in the record where that is. If I missed it, I would say.
Well, and I don't know, he'll have to speak for himself,
Yeah.
obviously, but it doesn't take a lot to put 2 and 2 together if all of a sudden you're getting all these evaluations over again and testing over again, right?
Well, yes, it does, because the hearing, these interviews, like in November, the hearing's the next day. So we don't have a situation, and there are, from the previous hearings, if somebody makes a notation, they have a notation, such and such a day, here's my interaction with Mr. Stutzman. So if that were true, they could easily have shown, here's what was reported this day, and they could have the timeline right up to it. But these interviews happened in August, November. The hearing wasn't telling.
So you're saying that there was no indication in the record that after the evaluation he returned to a normal type of...
Both. There's a number of things that happen. Let me give an example. One of the the state experts indicated were the mutism. They made a big thing that he wasn't talking at that time. But the evidence was very clear that he continued it after the first hearing. And the other thing was that, which Dr. Ashkenazi pointed out, that although he wasn't speaking because the network had kind of controlled him, to avoiding network rules, he was communicating writing. In fact, his communications in writing were clear. So it wasn't a matter of him not communicating, he did.
I read that and I'm like,
Sure.
that is not kind of sitting well with me either, trying to figure out how that worked, because if somebody tells you you can't give information or you can't talk.
Talk is different than writing. And here, this is
But was the evidence that he said that he was not allowed to talk, orally communicate, or he was not allowed to cooperate?
I don't want to misspeak.
That's okay.
But my understanding was that what he was told is you can't let anybody know that you're part of us.
Well, and then
And that was the restriction.
and that was kind of the understanding I was getting.
Yes.
So I was wondering, why is he allowed then to write?
I can't answer that question. I mean, who knows?
But you see, those type of things could be interpreted both ways.
I understand, but that's the point. We're not here to decide. That's my point. There's other reasons. For instance, all of the the prosecutor's experts, it's just my experience. Over and over again, what literature do you have to support that? You know, I'm told, for instance, Dr. Soner said, if you confront somebody under delusion, they'll get violent. Where's that from? He didn't know. It's all just based on their subjective experience.
Excuse me,
Yes.
did they actually testify as experts, or were they just doing, a historical testimony as to how he interacted with
Oh,
them?
Dr. Soner, in this point, was testifying as an
No,
expert.
I know the doctor. I'm talking about the social worker and the.
Oh, no, they
nurse.
gave opinions. At one point, I objected to their opinions because they weren't qualified, and the judge just waved me off. I mean, Marla Yoder, for instance, one of the problems, the first time, and she testified to this, when years ago, when he first came into Twin Valleys, she walked right up to him, originally said, stop it with this network stuff, I don't want to hear it. Well, he wouldn't confide in her. He hid it. He protected his delusion. The same when he was aware Dr. Smith was suspicious, he didn't talk to her at all about it. Her prior testimony here was, he never mentioned it to me. He was protecting it at that point in time, which is, as Dr. Ashkenazi explained, is consistent. It's not a one-size-fits-all situation. Dr. Ashkenazi testified, look, on the Sears, for instance, the SIRS testing, the rules of that testing specifically says you cannot use that test to rule out mental health. That's not what it's for. She gave the explanation on why she thought it was invalid. So you have two different opinions. Well, that's what judges do. And you're talking to a judge who's seen Rudney over a period of years. He's seen physically, he's seen his reaction to questioning, he's seen his demeanor in the courtroom, he's seen the up and down, certainly there had been. And so that's what we do. That's what judges do. They sit in the courtroom, they see it, they go through. Dr. Ashkenazi, in fact, originally had thought he was restorable and asked that he be put on medication. She's not a psychiatrist, she couldn't do that. In fact, the record shows he was on various antidepressants, some for sleep, but some for other reasons. And she testified there were changes in that time.
So he's on antidepressants, but he eventually was put on antipsychotics, I assume.
Well, the antipsychotics, the Haldol, was kind of a relatively brief period of time. And there was a doctor who no longer works there who prescribed it when he left, then they changed the prescription. So we have
But you don't take Haldol regularly, do you?
No, and he didn't
I was
take
gonna
it regularly. Yeah, the record, he wasn't taking it full time.
But what I'm asking is, if he is psychotic, why isn't he on psychotic medications?
He's not now. He was when he was taking the test. She thought he was when he was taking the test, but he wasn't actively psychotic in the courtroom, and he wasn't actively psychotic when she didn't read the
I'm not understanding, and I apologize.
Sure.
If you're schizophrenic, you're on medication all the time, for instance.
Well, I'm not a doctor. I can't
Nobody
say-
testified to that?
No. No, they didn't. That wasn't, there's no indication. I think she said she had schizophrenic traits.
Well, I didn't say
Yeah.
you had schizophrenic, but you're still arguing that he has a diagnosis of psychosis, right?
Oh, no, I'm not making myself clear.
Okay, that's okay. It's me,
No,
probably.
What I am saying, the reason the SIRS test, the SIR2 is not definitive, and the reason that Dr. Ashkenazi had indicated she didn't think it was definitive in this matter is because, in her opinion, when she administered, he was actively psychotic at that time. He was having an episode.
Counsel, if I could
Yes.
change direction
Sure.
just for a second here, if I could. Did I misread, or did Dr. Ashkenazi actually find that he met the first prong? In other words, that he was able to understand the nature and objective of the proceeding against him. It was actually the second prong she had concern with.
Yes, I think that's correct.
Is that a fair statement?
I think that's a fair statement. I think what she meant by it was he met the first prong.
I don't want to get into what she meant, what she said.
Okay,
She
here's
rendered
what,
an
yeah,
opinion.
okay, here's what she said. What she indicated was he did show an improvement over time with treatment, with drugs, on the knowledge of the system, in understanding how the system went. So for that prong, he did show that. Where he failed was that he was unable to assist, not meaning not getting along with or cooperating, but his belief was, and this was in the testimony, for instance, when asked about the jury, what about a jury? And he indicated, well, the network will take care of that. So he knew what the jury was, but he was unable to make informed decisions because he believed the network would take care of what he needed to, and he didn't bother. So I think it is a fair assessment that she indicated he did show sufficient understanding of the legal system, but the fact that his particular mental health issues made him incapable of making decisions regarding that in assisting counsel in his defense, because his position was and is the network's going to take care of it.
Will we find things in the record? We may or may not. The state alluded to it. I don't know if it'll be there, that he had some questions somewhere about civil commitments and that sort of thing.
Well, here's what that's about.
Well, I guess my question is, then he certainly knows some things about the legal system.
We're not disputing. I thought I just conceded that.
Well, I guess what I'm getting to is then there's that line between manipulation, malingering.
And that's
but
what I wanted
who's
here.
not to say that you can be incompetent and still manipulate?
That's correct.
You can be competent and manipulate?
That's correct. And the difference is, for instance, what the example used in the court was, he wanted to get to a lesser facility, a less restrictive facility. He understands that if he acts a certain way, maybe he can get less restrictive facility. So he can and is capable, and we concede, can manipulate. He wants to watch a TV show. He wants to get more medicine for his back. That's manipulation to his advantage, but that's different than malingering of mental illness. They're two separate things which she went through. The bottom line is, she explained this, the judge deciding that the evidence was in favor of Mr. Stutzman, it's based on what's there. I mean, it's hard for, and this court says it all the time, and others, look, I'm not there, I can't read them, I can't talk them, I can't see their reactions. There is a basis in the record for this judge's decision finding that he is incompetent. And that's what we're here about.
Counsel, at some point, even with abuse of discretion, decisions are unreasonable. Would you agree with that? I mean, otherwise, there would be no reason for an appeal on an abuse of discretion standard.
I want to make sure I answer.
Well, no, I'm saying at some point, trial court's opinions are unreasonable.
I agree.
Otherwise, we wouldn't even need to have an appeal on abuse of discretion even.
I agree. Absolutely. And so that's why I said originally, it's unreasonable. If you look at the record, it doesn't support his decision. There isn't something in it. And we have this, do you believe a expert who believes on research and objective testing, or do you like an expert that's based on my experience? The judge can do either. In deciding on somebody who knew him, her consistency in other hearings, watch, the totality of the circumstances, I don't know how that's unreasonable. It's not unreasonable because, two of the witnesses for the state, again, I don't think they should have been able to give opinions. One, for instance, there was an instance where the psychiatric nurse says, I think he's malingering. Why is that? Because he was talking to me about these hand grenades, and he said they went off to the side, and in my experience, they go out to the back of the head. What? You know, where is their research about that? Well, that's just my experience. Well, we don't know who he had diagnosed, we don't know what those other people are, but these are the type, I don't think that is reliable at all. In other words, there needs to be some research. A number of times I would say, where is the research on this? That's inconsistent, and there's no research, it's just my subjective opinion, and that's different. Every case is different. So when you're looking at the totality of the circumstances, the interpreting of tests, the consistency of testimony, or the lack of consistency or the lack of the background, when the judge, seeing all that, hearing all that, having been on the whole time, determines he's still incompetent, that's not unreasonable. You can disagree, but that's not unreasonable.
Now, you've had a lot of questions, so I'll just give you an idea. You've got about 2 minutes left.
Dr. Ashkenazi had seen him over a 7-year period. One of the things that's frustrating from a defense standpoint is that nobody, Dr. Ashkenazi did, but the state experts didn't come to us and say, why did you make this referral? Why did it take 6 months to make this referral? What is it about this that you found inconsistent? We reached out to them finally. Look, if you guys have a problem, you don't come in and watch. The law is very clear. If part of the prongs is to work with counsel, and counsel is the person who made the referral in the first place, the frustration is, how can you make this determination without ever speaking to counsel, without ever going through? As defense counsel, because it's our client, we're being advocates, we're not going to be straight. Is that the position, this presumption that we're not going to be straight with the doctor? Which is crazy, because nobody would do that. I hope nobody would do that. And that's a very important problem in this case. Why your difficulties? Nobody asked, what was it that he said? How did this develop? If this is a delusion and he's protecting it, how did it become uncovered? These are questions we weren't asked, which we'd be happy to do.
Well, by the same token, counsel, if you're conferencing with your client and you see signs that, I'm just going to hypothetically say, he's slipping out of that delusion, and it's potentially a defense in a capital murder case, you're not going to run to the state and say, oh, wait a minute.
Well,
Before you answer the question, I'll let you answer it, but you are out of time, so this will be...
Okay, I disagree with that position.
Okay.
Our ethical obligation is if we have a client who is not capable of making decisions in a capital case, we would violate every ethic that there is in pushing this forward without knowing how he is mentally.
But that wasn't what I posed to you, but we're done.
Okay, I apologize.
No, that's okay.
Thank you for the
question
argument.
was convoluted, to be
Okay,
honest.
all right. Thank you very much.
And the state will have 3 minutes and 47 seconds for rebuttal.
Hope I won't take that long. Some question was raised, well, how did Mr. Stutzman know that a hearing was coming up? I would point up what counsel just established. Dr. Ashkenazi, 7 years. She's been the defense evaluator since the very beginning of this case. If she shows up, Rudney Stutzman has a pretty good idea why. It's not the regular staff. Something is coming up. And as to the court hearing coming up, it wasn't so much the hearing he knew about, because the hearing is not the basis for determining his evaluation, for whether or not he's incompetent. It's the evaluation and his behavior. The court isn't just sitting there watching his behavior during the hearing to determine if he's incompetent. It's that evaluation. Mr. Stutzman knows that. He knows when somebody comes in and he asks, is this for a civil commitment? No, we're determining competency. And I think the court will find evidence of that not only in the record, but in the reports that were submitted and admitted by the court. So we're not judging his behavior at the hearing. We're judging his behavior at the evaluation, and that was when he indicated knowledge. We heard counsel say, what was that? Where's the research about that? I don't know what we're talking about so much in research. Most of the experts testified from their experience, education, and training. I do not recall, I could be wrong, but I do not recall any peer-reviewed journal articles being submitted, any treatises being submitted into evidence in the court. There may have been oblique references to they found this or they found that, but I don't know that we have any basis for any research from either side, from either Dr. Ashkenazi or any of the state's experts. So the opinions in this case have always been based on education, training, and highly on experience with Mr. Stutzman. Finally, why does Mr. Stutzman behave in a certain way? Counsel has indicated that Mr. Stutzman understands that he'll have lesser security or certain privileges if he behaves in a certain way, and that's why he does some of those things. But he also understands, and there's extensive evidence, that he knows what he is facing, that if he is found competent, he is back to county jail. It is standing trial for capital murder. So he understands that, and that his competency is the linchpin in that. Thank you.
Counsel, can I ask you just one question? It wasn't really in the briefs, but do you know about the age of the defendant?
I think he's in his late 30s.
Thank you.
All right, thank you both then for your arguments this morning. The court will take the matter under advisement and render a decision in due course. The clerk of courts will certainly mail both of you a copy of the decision on the day it's released, and the opinions are also posted on the Supreme Court of Ohio's website.